To continue our discussion on the power of control, we have the case of Tan versus the Director of Forestry. Here, a public bidding of a certain tract of public forest land was issued by the Bureau of Forestry through Notice Number 2087. Petitioner Tan submitted his application in due form after paying the necessary fees and posting the required bond therefor. However, former President Carlos P. Garcia issued a directive to the Director of Bureau of Forestry informing and directing the latter that the area formerly covered by the Naval Reservation be made a forest reserve for watershed purposes, and that bids received by the Bureau of Forestry in the public bidding be rejected. Jose Feliciano, as Acting Secretary of Agriculture and Natural Resources, promulgated General Memorandum Order No. 60, which revoked the authority delegated to the Director of Forestry. Notably in this case, the ordinary timber license issued in the name of the petitioner was without the approval of the Secretary of Agriculture and Natural Resources. Thus, Ravago Commercial Company sought the cancellation of the same on the ground that it was void ab initio. The issue of the case was whether or not the power of control by respondent was valid, which the Supreme Court answered in the affirmative. The Supreme Court concurred with the trial court's findings that indeed, Tan's timber license was signed and released without authority by then acting Director of Forestry, and is therefore void ab initio. Since the Director of Forestry no longer had authority to release the license, petitioner appellant had not acquired any legal right under such void license. According to the Supreme Court, the power of control of the department head over bureaus and offices includes the power to modify, reverse, or set aside acts of subordinate officials. Henceforth, the Secretary of Agriculture and Natural Resources has the authority to revoke, on valid grounds, the timber licenses issued by the Director of Forestry. Moving forward to our next topic, the President's power of general supervision over LGUs and autonomous regions is encapsulated under Section 4, Article 10 of the 1987 Constitution. To wit, the President of the Philippines shall exercise general supervision over local governments, provinces with respect to component cities and municipalities, and cities and municipalities with respect to component barangays, shall ensure that the acts of their component units are within the scope of their prescribed powers and functions. In essence, the power of general supervision simply means overseeing or the power or authority of an officer to see that the subordinate officers perform their duties. If the latter fail or neglect to fulfill them, the former may take such action or step as prescribed by law to make them perform their duties. Relevant to our discussion on the power of general supervision is the case of Judge Tadole et al. Versus the Commission on Audit. Here, the Department of Budget and Management issued the disputed Local Budget Circular No. 55, which provided conditions to the authority granted to the LGUs in providing additional allowances and benefits to national government officials and employees. Acting on the DBM directive, the Mandaue City Auditor issued notices of this allowance to herein petitioners. Petitioners now argue that the Local Budget Circular 55 is void for infringing on the local autonomy of Mandaue City. They maintain that said circular is not supported by any law and therefore goes beyond the supervisory powers of the President. They further allege that said circular is void for lack of publication. The issue at hand was whether or not the Local Budget Circular of the Department of Budget and Management is void for going beyond the supervisory powers of the President and for not having been published. The Supreme Court ruled that, while it is true that the Constitution guarantees autonomy to local government units, and the exercise of local autonomy remains subject to the power of control by Congress and the power of supervision by the President, it is likewise true that the President or any of his or her alter egos cannot interfere in local affairs as long as the concerned local government unit acts within the parameters of the law and the Constitution. The Supreme Court said that the DBM overstepped its powers of supervision over local government units by imposing prohibition that did not correspond with the law it sought to implement.